happened over the last couple days. I've done some reels and some shorter videos and some Instagram lives, but I did want to come on and talk to the OG big group here, the chat, about these topics, because this is going to be interactive. I am going to have questions for you, our potential jurors, and how you look specifically in the Gabby Petito case at this burn after reading letter. We are going to read it together. JB Bueno has posted it on WFLA. He did a stream last night reading it. I think he was literally the second person to see this letter or have access to it and post it, which is awesome. Literally breaking news. So we're going to read it together. And then I have some questions, and I think it will be questions the lawyers are going to ask of the jury. And even if they don't ask them, there are questions the jury is going to have to answer about this question, about this letter, I should say. Before we get to the letter, I just want to real quick, because there are some questions on the motion to dismiss. So there were multiple motions to dismiss, amended complaints by Bertolino, the lawyer for the Laundries, and the Laundries again. Basically, Bertolino's lawyer actually thought did a pretty good job. And I think there's a chance it gets dismissed, but even if it does get dismissed, like one of the last ones, they will probably have the opportunity to amend. The Petitos would have the opportunity to amend the complaint and refile it, which is common practice. But his main arguments were that Bertolino did not actually cause the extreme emotional distress. It was what happened to Gabby and Brian that caused it. And the plaintiff, Petito's lawyer, Pat Riley, responded by saying concurrent causes of the emotional distress. He said the actor, Bertolino, did not target the Petitos. Words like this could never rise to the level of being extreme, saying that you hope and pray for someone. You can't be sued for that. The statements didn't actually cause the distress. The lawyer was acting on behalf of the client, not actionable. His statements were legally permissible, just like, and he explained a doctor telling I actually can't remember what he said, but what popped into my head when he was saying that is that makes sense, because it's also like a doctor telling you you have an STD. It's like, well, that statement sucks, and that statement's breaking the news to you, and that's going to cause severe emotional distress, but the statements aren't what caused it, and the doctor has an obligation to tell you, so you can't sue the doctor for saying that to you. Okay, so that's kind of the argument that he was making. So the judge is going to reserve ruling. Laundry lawyer, I think Matt Luca kind of repeated some of what he said, repeated some arguments we've already heard. There was a lot of eye rolling and almost giggling by the Petito parent. Not giggling like they thought it was funny, but like sarcastic, like, yeah, right, eye rolling, like, huh, oh yeah, that's what you think? That kind of giggling, or laughing during some of the presentation by the defense lawyers. It's unthinkable what they're going through, impossible to put yourself in their shoes. So I see some people condemning it. I agree we should try to keep it as straight face as we can in court, but I represent a lot of victims' families, and I know that that is them containing their emotions because they want to come out of their skin and just go after the defendants sometimes, especially when they make certain comments. So let's give grace all the way around, lawyers doing their jobs and victims dealing with very, very difficult times. So then we get to the burn after reading letter. And how we got here is Pat Riley has seen this early in the investigation. They've asked for it in discovery. The Petito's lawyer, Pat Riley, not the Miami Heat coach, old coach. And the Petito's the Laundries filed a motion for protective order, saying this was embarrassing, intrusive, has nothing to do with this case. There was an affidavit where Roberta Laundrie said, I wrote it before, has nothing to do with Gabby. It was inside jokes, basically, between me and Brian, just about a mother's love. Okay. So they filed that motion for protective order, and that's what the judge was ruling on today. And basically, Matt Luca said, this is really embarrassing. And he starts to mention the context of the letter. And the judge says, hold on. Not fair to Pat Riley if you're going to argue context and what the letter says if he doesn't have a copy of it. And she's absolutely right. How can a lawyer make an argument like, no, this context does show that it was written before? No, this context shows it was written after, if I can't read the context and use the words myself. So basically, everybody agreed Pat Riley was being handcuffed and hamstrung here to make these arguments. So Matt Luca's like, whoa, fine. I won't use the context. I won't use the words. He makes an argument. It's very clear to me that the judge was leaning and tipping her hand a little bit a couple different ways. It seems like a very smart judge. I've never had a case in front of her. I've had some in front of Hunter Carroll and been on some committees with him and know him pretty well. He's a good dude, really good judge. She seems really smart. And I kind of like her disposition. It seems like she's a little sarcastic maybe in her personal life, but I like that a little bit in a judge because they're like, come on, let's just cut to it. When the Laundries made the argument that, well, when they said in the statement they could be reunited, maybe they mean with their ashes. She's like, oh, so you really think that's what people think when you said hopefully you're reunited, that it could be with the body after it's no longer living? I like that because it's like, let's be honest here. Okay, let's call a spade, as people say. So the judge was tipping her hand a little bit because when they were arguing the motion to dismiss, they were like, well, what if they take out these paragraphs? What if they edit it this way? So I think she is going to potentially make the plaintiff make some amendments. The plaintiff even agreed to make some amendments to the complaint. Then when we come to the burn after reading letter, the judge, again, did not think it was fair that Pat Riley didn't have this letter, number one. Number two, she wasn't thinking it was rising to the level of needing a protective order. But number three, I knew she was going to deny this protective order and allow the plaintiffs to have it, but I think she would have said, let's do a confidentiality agreement around it. She even mentioned it, asked each side what they would think about it because there was a confidentiality agreement to some other financial records in the case already. And that's part of the hearing I want to play because both lawyers were adamant that they did not want confidentiality. And sources have told me that potentially the defendants, the Laundries, leaked the letter before anyone from the plaintiff side even gave it to anybody. So let's listen to these arguments a little bit about confidentiality. And I want to explain to you why a lawyer would do stuff like this and not want confidentiality and how sometimes they make it very obvious without even saying it. He just finished his argument.
Say I agree with you, Mr. Riley. What argument would you have against a confidentiality?
Why?
So say I agree with you, Mr. Riley, because she does. I like the way we've already talked about this. I love when judges telegraph what they're going to do because if I need to change my argument, I can, or if I'm winning, I'll sit down and shut up. And she's like, so what argument do you have against confidentiality? Because judges usually don't like stuff going through the media. They don't always throw a gag order in there, but if it's something sensitive like this, that one party doesn't want out, at least offer something that seems like a compromise. I like that. But it is ultimately up to the parties and the lawyers whether or not they want a confidentiality agreement in this situation. So let's see what he argues.
I have no reason to agree to a confidentiality agreement. I mean, that hampers me. Why would I agree to a confidentiality? So then if I'm...
So he says the confidentiality agreement hampers him. And now he's going to explain how it hampers him.
Her about it in a deposition. So now the deposition transcript is going to be confidential as well, or a portion of it. I mean, I don't see a reason why I need to be hamstrung.
So I think he makes an excellent point that there is no reason for a confidentiality agreement in this situation. And why are we just making things confidential? Are just certain, and this is something I would have added to it, but I think he didn't want to make it seem like I'm just going to give this to the media because it's so good for us, even though that's part of it. They are winning this case in the court of public opinion. Frankly, Pat Riley just continues to win and win and win and win in this case. Now, will it end up getting all the way to trial? We'll see. But even when he loses a motion to dismiss, he wins because he can refile it. And he wins this argument and he wins the motion for protective order as well. So he's saying, Judge, what I would have added to it is just this one thing. So, Judge, if there's a bad fact for my clients, can I come in here and get a confidentiality agreement for that bad fact? Confidentiality agreements are in place and protective orders are in place to protect private information, social security numbers, bank account information, not a bad fact or a bad statement that a defendant makes. So that's all I would have added to it. But basically that's what he said. And he's right. So now when I ask her about the letter in her deposition, he says, now the whole deposition's confidential? Come on, Judge. Might as well have a gag order on the whole case.
We're not talking about financial information, which would be the appropriate subject of a confidentiality agreement. We're not talking about trade secrets. We're not talking about something that if is disclosed is going to give some party an advantage, an outside party an advantage in moving forward, such as if trade secrets were disclosed. That's not what we're talking about. We're talking about a letter in the handwriting of a party.
He's right. So what's the most interesting part about this is the defense, who it's bad for, you would think would want a confidentiality agreement, right? But oh no. Matt Luca has thought about this already, and I think correctly, and he's going to mention exactly why the defense doesn't want a confidentiality agreement if the judge is going to deny their protective order.
Mr. Lee, do you have something to add to that?
Your Honor, I think at this point, we probably wouldn't be in favor of a confidentiality agreement on this issue either, just because Mr. Riley just put probably the two worst parts of the letter on the record in open court. So, I mean, and that's what we would be dealing with that throughout the litigation. I mean, he can.
Okay, so you don't want to, you just want me to rule then?
I think we just want you to rule.
Okay, very good.
So a couple things. Number one, not agreeing to a confidentiality agreement does two things for the defense, and I think it was a great move by Matt Luca. Number one, the worst statements about the file in the cake and bringing a shovel if there's a dead body or whatever, he already said those in open court. Everybody's already reporting on those. So at this point, the first thing it does for the defense is it allows them to give context to those statements. And we're about to read the entire burn after reading letter so you can see what that context is, and I'm going to ask you questions about it. That's argument number one. Argument number two, it takes away the compromise from the judge. So maybe it's a Hail Mary last-ditch effort to try and put a little extra pressure on the judge. Like, this is a really important ruling, judge. You can't deny the protective order and just give confidentiality. Everybody's either going to see this letter and my client's going to get embarrassed, or you can do the right thing, in his argument, and grant the protective order. So it does two things. Gives context if she does allow it in, but number two, it puts a little added pressure on the judge's decision and takes away any compromise or splitting the baby that the judge may have been able to do. So I actually think it was a really good argument by Matt Luca, or good decision, I should say, by Matt Luca. And as we know, the judge denies the motion for protective order and the burn after reading letter comes in. So before we get to that burn after reading letter, I thought it was interesting to listen to the comments of the lawyers after the hearing. And I also think Matt Luca is not surprised that he lost that hearing, and he's not going to be surprised if the case doesn't get dismissed. But I do think it is very, very interesting to hear the lawyers' comments after they lose a hearing, after they win a hearing, but the case is still ongoing. So let's listen to first Matt Luca and then Pat Riley.
You guys ready? Could you just say your name and spell it so we get it correct?
Matt Luca, Luka.
I guess, how are you feeling after all the motions? We know that the judge is going to rule on two other motions as well. Just how do you feel moving forward?
Well, it was obviously a long day, and we appreciate Judge Brewer giving us as much time as we needed to take. She was very accommodating in that regard. I feel pretty good. Feel about as good as I did walking in. We were able to make all of our arguments, and hopefully they'll be persuasive.
Yeah, with letting them use the letter as well, we know that the letter has now been handed over to Mr. Riley. What are your concerns in that?
Well, obviously we were concerned about how the letter might be used, that it could be embarrassing and whatnot. But it's part of the case now. It's part of discovery. And so I'm sure it's something that we will address again as the case progresses.
Is there anything else you'd like to say about that letter? We know that we were told that there was references to children's books, but just hearing Mr. Riley, it didn't sound like that.
Yeah, we disagree with Mr. Riley's characterization. So within the letter, you'll see that there are references. I know Mr. Riley referenced two things in the letter that, taken out of context could be inflammatory, but they appear in a series of sort of fanciful descriptions of how much somebody would love somebody else. So, for example, if I there's a reference in there about if Brian went to the moon, his mother would be waiting for him to come back. If Brian hated his mother's guts, that she would get new guts. Things that are obviously not real. They're just fanciful descriptions, again, of how somebody would love somebody no matter what. And so in that context, we believe that the letter, as Mrs. Laundrie said, was written prior to Brian and Gabby's trip. The letter doesn't reference Gabby in any way, which would be unlikely if it was written after what happened between Gabby and Brian. And
I think this is good. You get a little argument from the defense attorney before we read the letter together.
that's our position, and we believe the facts will eventually bear that out.
Can you prove that the letter wasn't given to Brian on his flight back, Moab?
Again, other than what Mrs. Laundrie has stated in her affidavit, that's our proof. There's certainly no proof that she gave it to him at that time that you described.
I just don't think that they would put burn after reading if it was just a letter to your son.
Well, so if you look at Mrs. Laundrie's affidavit, she states in there that that's a reference to a book that Gabby had given Brian. It was called Burn After Writing. And basically the premise of that book is you can write your personal thoughts down and have that outlet, but then you burn it after writing it so that it gives you some closure to whatever it is that you were describing without other people knowing your personal thoughts. Thank you.
Matthew Luca speaking here outside the courthouse in the aftermath of, you see there at the beginning, motions to dismiss. Here is Pat Riley.
This is the Petito's lawyer.
But as you said, Judge Carroll has really already made these rulings. So much discredit as a judge to go back.
I would agree. I think the arguments that were made, if I were Judge Carroll, would be insulting to me because they argued that he didn't give a thorough consideration to all of the elements of the cause of action, which is clearly not true. His decision was very well written, very reasoned, and he took his time putting it together. So I think they're just seeking another opportunity to raise the same arguments.
So here's one spot I'll disagree with Pat Riley. I promise you that Judge Carroll was not insulted by a lawyer disagreeing with his ruling or using a very appropriate means of an additional motion to dismiss or motion for reconsideration. Judge Carroll, like every judge knows, they are going to be given credence from their prior rulings, number one. Number two, judges get overturned sometimes. They try not to. And number three, they expect lawyers to represent their clients, as he did when he was a lawyer. And I'm sure he disagreed with certain judges' rulings from time to time. It does not mean you're insulting the judge, but where I agree with Pat Riley is any chance you get to show you and the judge are on the same side, you and the judge see something the same way, you might as well double and triple and quadruple down on it, because that is what you need at the end of the day. Until you get to the jury, you want the judge to agree with you, agree with your ruling or with your arguments and rule in your favor. So I just thought that was interesting that he said that, a little bit. If you don't know and you don't understand the process, you might think that someone would be insulted from that, but there's no way Judge Carroll would be insulted.
And they should fall.
Are you concerned that, I don't want to call it a waste of time, but that they'll continue to drag things out with motions like this?
Well, if the court denies their motions, then there's nothing more they can do to stop it from moving forward. We'll begin or continue with the discovery phase and then ultimately move towards trial.
How do you feel getting that letter in your hand today?
It's a victory. We're happy to have it. We fought hard to get it. We've been fighting for over a year to get that letter.
And once you have that letter, we've heard some of the phrases, some of the wordings that are written in that letter. How do you think that will help the case?
Well, the letter suggests that Roberta Laundrie would, if she needed to bury a body, she'd bring up a shovel and garbage bags. It said that if she went to jail, she'd bake a cake with a file in it. I know in court I said shiv, but that was my recollection from a year ago. It does say file. So in my mind, that clearly shows that she knew that Gabby Petito was deceased. And it's up to the jury to decide when that letter was written. just because Mrs. Burr.
And now you hear some arguments from the plaintiff's attorney. So we're going to hear these two arguments. I did this purposely. This was the plan of the video. So you hear their arguments, then we're going to read the letter together, and I have some questions.
Mrs. Laundrie says it was written before the trip, doesn't mean it was written before the trip.
For the family too, not having Brian alive to go to trial, how will this continue to help with not closure completely, but just closing out that chapter?
Well, the whole intent of this is to get answers. There are still many questions that the Petito family has about what the Laundrie family knew, what they did with the knowledge that they knew, and really why they didn't come forward and say anything.
So they're saying they have questions about what they knew, but they're also saying they know that they knew it. So I don't know. I mean, there is some interesting parts about this because they have to prove what they know at this point. They have pled in the complaint what the Laundries knew, but he's still saying they have questions about what they knew. It's just kind of an interesting, it's such a novel case. It's a new case that I've never seen anything really like it.
I don't know that that question will ever get answered because the court has found had the right not to say anything, but there's a lot of questions that the family would like to have answered before they can get, if you can get closure at all in a situation like this, but at least get some closure. All right, thank you.
Pat Riley.
All right. So let's get to the letter. And we're going to read JB's transcription of it, and then I'll show you what the letter looks like first. It's just easier to read because JB did everybody a solid by typing it all out. So here's the letter itself. I think it's on screen now. Yeah. So here's what it looks like. 2 pages, and here's the front. Brian Christopher Laundrie, burn after reading. Okay. So while I'm reading the letter, so here we're gonna do a couple things together. Okay. John, don't post the poll yet. Somebody asked, did Brian write the letter to his mom or other way around? Mom wrote this to Brian. So here's the question. As I'm reading this letter, I'm just going to read through it once. Write one word in the chat or in the comments. Write one word. The one word this letter makes you think. Whatever it is. The one word this letter makes you think or feel or whatever it may be. All right. I just want you to remember I will always love you. I know you will always love me. You are my boy. Nothing can make me stop loving you. Nothing will or could ever divide us, no matter what we do or where we go or what we say. We will always love each other. If you're in jail, I will bake a cake with a file in it. If you need to dispose of a body, I will show up with a shovel and garbage bags. If you fly to the moon, I will be watching the skies for your reentry. If you say you hate my guts, I'll get new guts. Remember that love is a verb, not a noun. It's not a thing. It's not words. It is actions. Watch people's actions to know if they love you, not their words. Therefore, I am certain that neither death nor life, nor angels, nor the ruling spirits, nor things present, nor things to come, nor powers from above, nor powers from below, nothing in the entire created world can separate our love. Neither hostile powers, nor messengers of heaven, nor monarchs of earth, nothing has the power to separate us. Romans 8:39 extended version. Nothing can separate us, not hatred, not hunger, not homelessness, not threats, not even sin, not the thinkable or unthinkable can get between us. Not time, not miles and miles and miles. So that is the burn after reading letter. I'm going to get to some of your one-word comments now. Read them out here. Nasty, conspiracy, disturbing, weird, body, sick, odd, definitely think odd, enabling, creepy, sloppy, permission. So even if it was written before, okay, we're going to get there. It's interesting. Knowledge, desperate, twisted, accomplice, accessory, codependent, guilty, narcissistic. All right, so pretty much all are negative. which is understandable. Okay. So now we get to some of our questions. John, you can post the poll now. So as we read it and dig into it, and we've already heard some arguments from the plaintiff and some arguments from the defense, do you think, just based off what you know, do you think this letter was written before or after the crimes were committed? That's going to be the poll that John's going to post. And you're going to vote on. So as we kind of talk through this, I'm going to read through it, pull out some phrases, ask you some questions based on those phrases. The poll is live. Because there is some interesting aspects to it. First, the defense made the argument that there's no reference to Gabby. But they also say that, I believe, either the children's books or the Burn After Writing book or conversation is a reference to Gabby. Just an interesting thought. Number two, they say they reference children's books. I have not read them. Pat Riley has them, and he says there's no reference to the children's books. Okay. Number three, there is nothing specific about their trip, about a missing person, about Gabby or something happening to Gabby. Gabby lived with the Laundries. There is evidence and context that they had a good relationship. So maybe that does prove that this was written before Roberta Laundrie's context that she puts on it. Oh, there was also a text that she wrote. Let me see if I have it here. I thought I had it. So her affidavit had context on it that that said this, or her affidavit said that they were struggling, their relationship was struggling. She wanted to make sure he loved her and that he knew she loved him before he went on this long trip. And here is a text that I got that people say is from Roberta Laundrie. The letter to Brian was written prior to Gabby and Brian leaving my home for their trip. Previously, I submitted an affidavit to the court for very limited purposes, but that is not the whole story. Excuse me. Woo. Now that the letter has been shared, I ask that you read it in its entirety. This was prepared by the defense, I think. And understand that the letter contains other phrases besides those highlighted by Pat Riley for sensationalism and to bolster his case. I truly loved my son and simply wanted to convey to him how much he meant to me and how much I loved him. I am sure people use phrases all the time to express to their loved ones the depths of their love. Although I chose words that I thought would be impactful with Brian given our relationship, the letter was in no way related to Gabby. Please read the entire letter before you believe the hype put out by Pat Riley. So this case is absolutely now, if it wasn't before, being fought in the court of public opinion. So let's talk about some context. If I was Pat Riley, some things that I would say reference that she knew either what Brian did or she had a sneaking suspicion based on what Brian told her. And this was her basically offering help in the situation that he was in. These are things I would highlight at trial, highlight in her deposition, see what answers she has about them. And if her answer is just, well, they were just sayings and phrases and they didn't mean anything, I think I can work with that at trial if I'm Pat Riley. So first, nothing can ever make me stop loving you. Nothing will or could ever divide us, no matter what we do or where we go or what we say. So on one hand, the defense could argue that's what a mother says to her son. I would say the same thing to my son, or what a father says to his son, I should say. Either. But then with the context of, if you're in jail, I will bake a cake with a file in it. So right after, no matter what you do, I will still love you. If you're in jail, I'll bake a cake with a file in it. Not something I'd say to my kid. And I think that's what jurors are going to do. And that's what I want you to do. Is all of this something you'd say to your kid? Some of it something you'd say to your kid, or none of it something you'd say to your kid? These are the questions for the jurors. If you need to dispose of a body, I will show up with a shovel and garbage bags. Again, I want you to answer these questions in the chat and in the comments. So bake the cake with a what? A file is like a sharp object if you're in prison. So you can either, use it to make a key or maybe fight your way out or whatever. So the shovel and the garbage bags, definitely not something I would say to my kids. If you need to dispose of body, okay. Now, here's an interesting thing. If you fly to the moon, I will be watching the skies for your reentry. Could have an innocent explanation, or it could be referenced to the manhunt where nobody knew where Brian was and everybody was looking for him. If I'm Pat Riley, again, I'm putting my Pat Riley cap on here, plaintiff's lawyer cap on, which is a lot easier for me to do than the defense cap. But I would say, so you wrote this, I'll be watching for the skies for your reentry while Brian is on manhunt and there's a manhunt looking for Brian. Then I would go to where is the unthinkable part? Oh, here it is. Nothing can separate us. Not hatred, hunger, homelessness, while Brian was gone and disappeared and ran away from your house. Threats. Were you getting threats from people during this time? Not even sin. Would you consider what Brian Laundrie did a sin? Answer would have to be yes. Not the thinkable or unthinkable can get between us. Would you consider what Brian Laundrie did to Gabby Petito unthinkable? Those are the questions I would have for Roberta Laundrie during her deposition. Not time, not miles and miles and miles, and this was after Brian Laundrie ran away from your house. Those are some of the questions I would ask Roberta Laundrie. And so some of you have already been posting. It wasn't specific enough. Whoops. It wasn't specific enough. Other people saying it would have been more direct if it was afterwards. And Nancy thinks it's a nothing burger. Lowe said the letter struck me as a mother who was desperate and disconnected. That being said, the Laundrie's behavior is abhorrent, in my opinion, and I have little sympathy for them, if at all. Without proof of when the letter was written, I don't think I could give it much weight if I was on the jury. Hope there is a lot of other evidence. So right now, about a quarter of you have voted, and 67% think the letter was written after the crimes were committed. And 1/3 of you think before. Missy, how would you be able to prove they knew? It would purely be based on context. They would have to show, based on the timing, based on what she said. But I think it's a tough argument. I think it's a tough argument as to when this letter was actually written, but it is definitely going to be a jury question. Unless the Laundries have some proof that it was written before, then I don't think they can even use this at trial. Jilly Bean says DV doesn't happen overnight. So it could be referencing other things Brian did in his life, potentially. I think that's an argument as well. Maybe the Laundries will say he's done some unthinkable, horrible sins in the past, and that's what we were referencing. I don't know. Rebecca, glad you're joining us. Peter, regarding letter, one word. How many in the chat are mothers? May skew results. Also regarding poll, need undecided. Well, I don't want undecided yet, right? Because everybody should technically be undecided. We don't have enough information. But with the information we have, if you had to make a call, because if you're on the jury and you say, I'm undecided, well, I would say make a decision, please. And so if undecided actually means I don't think they proved the plaintiff that it was written after, then you have to say before. That's the greater weight of the evidence. And I do agree. I would like to know how many are mothers. Alley Cat, I have a borderline mother and a very manipulative grandmother. This reminds me of something they would write to convince me to do something as a way of permission. Interesting context there. What else but Brian's crisis after killing Gabby would motivate such an impassionate letter? And again, that's a question Pat Riley will probably ask Roberta Laundrie, and we'll see what she says. Crazy Cat Queen, if Laundrie's lawyer, Luca, knew the letter was written after Gabby's death, is he allowed to mischaracterize, lie in court in order to defend his client? So he's saying Roberta Laundrie told me, and she said in her affidavit this was written before. That's what lawyers are supposed to do. They're the mouthpieces of their clients. Thoughts on Riley having the book's RL reference? I think it's great. It's exactly what he should do. Do his research. Lauren B. Saw you on Megyn Kelly. You have been the most fair and balanced and reasonable attorney on YouTube. Hey, I appreciate that, Lauren B. That's the goal, right? Barbara. What else? Oh, I read this one already. Man, I need more context. Do we know where and when the FBI found this letter? I think Brian had it on him and didn't burn after reading, which again, that's going to give more context. Where did they find this? So if this was written 6 months ago, why did Brian still have it? If she gave it to him on his way out with Gabby to go on the trip, like I think she said, it would make sense that he would have it. And if she wrote it afterwards and gave it to him, would also make sense. Fly to the Moon, probably loose reference to Goodnight Moon. I've actually read that, Crazy Cat Queen, to my kids. Cindy Lou Who. She said will, which is actionable, not would, which is a sentiment of wishing. She is either forgiving him for his actions, giving him permission if it was written beforehand. Very cringy. So, Cindy Lou Who, this is what jurors do. They find something that they think tells them something, and they discuss it with the other jurors. Keeley, I vote calculated and cryptic. Why would it be one of the last things to have in his possession? She sent him off with it. Again, that's the point of this discussion, to see what you think and why. Amanda Hubbard, pics of the letter show less wear and tear than his notebook that was found. Oh, this is what I need from you guys. Lawyers don't think of everything you're going to see. But this is a good argument that it's not very old. Christopher, this was a mom's way to save him from suicide after the fact of him leaving the woods after their vacation to stop him from hurting himself. Knowing what he did, she wrote this to him. I think that's a pretty fair guess at what this was. And also, let's just be clear. If Roberta Laundrie wrote this letter after Brian Laundrie told her what he did, it still does not necessarily mean the Petitos are going to win this case. It just means that would make this letter very relevant and come in at trial for the jury's consideration. Kathleen, I think reference to Miles and Miles allude to possible flee. Reference to the moon alludes to possible suicide. So I think she wrote the letter for Brian to read as he decided what to do. Very possible. And again, does not necessarily mean that they're going to win the IIED claim. Or I should say lose from the Laundrie's perspective. Adam Ace, will he definitely be able to question them? Yes, he is going to take their deposition. We'll see how much they plead the fifth. Sounds like she's going to answer questions around this. She's already given her affidavit, so I don't think she can plead the fifth on questions around this letter, or I would argue that she's already waived that. Elizabeth, I can't even. I probably would help the authorities if I knew my child murdered someone. Still love them, but they'd have to face the consequences. I don't disagree with that. I think there are consequences to actions, and that's why parenting is important throughout their entire life, not just after they do something like this. Mouse, a.k.a. Sandy, I might have missed it, but what remedy is being sought here? They're trying to block the letter from being used at all, and they lost the Laundries. Stephen, I don't understand. Why write such a passionate letter before and say burn it? It was to mend their relationship, but burn it? That's a good point. Evangeline, I think the words across the front of an envelope says it all. Burn after reading. The parents knew. The letter was in the van when he returned with it. Okay. We're going to have to get some actual context around when and where the letter was found. She is an accomplice, Rebecca said. Taminator, the letter is a mother coddling her murdering son. I think it's definitely a bit of coddling. Now, whether or not he did it, or whether or not she knew he did it, I should say, is the question. Melissa, JB on WFLA has already read the letter. Correct. He did it last night. Stina G, her affidavit said the FBI had a copy before they found his body. So either she had a copy, weird, or it was somewhere else. And this is where we need a little more context, I think. Jessica, while I would never say these kinds of things to my kids, if I were to write a letter to them to mend a relationship or let them know how much I love them, I would hope they would keep it and cherish it, not burn it, in my opinion. I agree with you. And I also think like some letters you write to loved ones may be embarrassing, or people may not get inside jokes or conversations that you've had before. I think that's very possible. These are some dark inside jokes. I think everybody would agree with that. And I think more than embarrassing, maybe damning is what the defense really meant. Amber, letter was found in a dry bag with his remains. So we will see and keep track of what happens in this case, continuing on in litigation. I am definitely interested in how it's used and what is said about this letter. All right. So here's what we're going to do. I am going to run our intro again, and then we're going to roll into the Brian Kohberger situation and case. I'm going to run to the bathroom while this intro is playing. Hit that like button if you haven't already. Subscribe if you haven't already. We're going to transition into the Pennsylvania grand jury situation and potential alibi and things the state is asking for in Brian Kohberger's case right now. So that's it for Gabby Petito. Let's roll it into Kohberger.